This is the plaintiff, Edward Silvio Emery. He says he was hoodwinked by the defendant into buying a car he was selling. The car's no good. The guy knowingly sold him a piece of junk. And he wants the $300 he had to spend fixing it back. So he's suing for just that today. This is the defendant, Chris Day. He says he has this guy's title for the car he bought, and all he has to do is finish paying him the amount he's owed. This car is his. He's not taking it back. It's a good car, and he thinks the judge will agree. He's accused of unloading a Hooptie. The defendant has filed a countersuit for $500 for the balance on the car, plus repairs.
All parties, please raise your right hands. The People's Court is now in session. The Honorable Judge Marilyn Williams presiding. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome.
Okay, Mr. Emery, tell me what happened.
I befriended this man, and he has misrepresented a car that he sold me.
Okay.
Yes, for $200.
How did you find the car? For $200?
Yes.
Okay, what kind of car was it?
It is a 2002 Pontiac GM.
Was it operable?
No.
Okay, well, you knew that when you bought it, right?
Yes, I had to have it towed home.
Okay, so you had it towed, and then what happened?
And then I opened the hood, and first I was told it just needed a battery, and lo and behold, it needed a brake cylinder, and either fuses were missing, and the whole right side of the compartment for the engine was empty. Looked like it was used for parts, in my opinion.
Well,
because there was a fuse missing.
Okay, so what do you do with the car? You tow it to a mechanic, and what does a mechanic tell you?
It would cost $1,000 to have the car repaired, and he would not repair it because it's junk.
Okay, so then what happens?
Then I left the car in the parking lot, and for some odd reason, the owner of this mini shopping center decided to have, quote, this junk car towed, and I have contacted my attorney in order to retrieve the car.
Oh, so you don't have the car now?
No, I don't. It's somewhere in somebody's tow lot.
Well, you don't even have the title to the car, right?
That's right. Chris still has the title. I am.
What? Okay. If your testimony is you paid in full for the car, why didn't you have the title and register it in your name before you parked it in somebody's parking lot?
I trusted Chris that he would certainly provide me the title, and I was going to give him $100 for the title if he asked for it, but
so the agreement was that you paid him $200 and then you would pay him another $100 for the title?
Exactly.
Okay, so...
And then I saw all the repairs that this automobile needed. That was exorbitant.
And then what happened? Then your car got towed and now you want your money back, but you don't have a car to return because it wasn't registered in your name, so you can't pick it up from the tow company.
Hopefully my attorney resolved that problem.
Oh, that's totally not happening. How long ago did the car get towed?
3 days ago.
Yeah, that's a problem because the only people who can pick it up are the people in whose name it's registered. And my understanding, Mr. Day, is that the person in whose name is registered, he asked you to sell the car for him. He's a customer who you did work on the car for. And then, unfortunately, he had a stroke or something?
Yeah, he had left the car in my possession. We had started repairing it before he had his medical accident. And I had purchased quite a bit of parts, a couple $100 worth of parts, and got it to where it almost needed to be done, but he lost interest in it because he was not allowed to drive anymore. I supplied the parts that were still not installed when I gave the car Mr. Emery. I let him leave the $200 deposit for the parts that I had.
Well, where's the paperwork from this sale?
He was pretty much a verbal agreement. He had paid.
How does an owner of an automotive LLC in Ohio do verbal agreements for the sale of a car? You know you have requirements to put stuff in writing?
No, I have my invoices from the original client and for what he paid for. He asked me as a
That's not what I
favor
was
to sell
asking.
the
I'm asking
vehicle
about
for
the
him.
sale of this car to this fellow.
He did not purchase it. All he did was leave a deposit.
Why does he have your client's car? What is the agreement, according to you, that you reach with the plaintiff?
I allowed, because he was a longtime customer, I allowed him to move it to his property to finish
But it's not
repairing
yours.
it.
It's the other guy's, the guy who had the strokes.
Right. Ed knows that the purchase price was $600. He kept changing the price. He would say, I've got 75. I said, Ed, keep saving up. Well, he brought $200 and I allowed him to move it to his property to work on it. He would get the title when he paid the other $400 so I could pay the owner of the car.
So what happens?
That's been the agreement all along.
That'd be really nice if you had it in writing, so there wouldn't be this dispute. And I'm a little bit concerned that a guy who owns an auto sale place, is that what it is, or a mechanic?
Repair shop.
A repair shop
a repair
doesn't put this sale in writing, because you put everything else in writing, right? So why didn't you put this in writing?
With Mr. Emery, we didn't think we had to. He's been a client for over 12 years.
Well, what do you think now?
Well, I see where his standing is. It's a shame.
Well, it sounds like maybe you should have put it in writing, right? Because you are in litigation in front of America. So what happens in the end?
Well, he hasn't. I have not heard anything about this.
Oh, so the first time you hear the car got towed was now?
Yeah.
Can I ask you, Mr. Emery, how was the car, if it's not running, what was it doing in the parking lot of some shopping mall?
Because I took it there to have it repaired, and it was parked almost front of their door, and then they looked at the car and they said, it's junk, it's not worth repairing it.
And then you didn't pick it up, so they just put it in the parking lot?
They just left it there. I don't even think they moved the car at all. So basically somebody
How
decided
long was
that the
it there?
car, I want to say probably a week.
Yeah, but why would you leave it there for a week?
I live nearby. I live within walking
No,
distance,
how could,
actually.
I know it's convenient for you. My question really is, why would you leave your car illegally there for a week? Because you don't have a right to leave it there for a week.
Well, I didn't think it would be illegal because it is a public parking spot.
It isn't. It's a private property. It's private property, and you kept your car there for a week. So the owners of the mall got sick of looking at it. How could you not predict that was going to happen? You can't just leave a car that is not titled to you, that is not registered to you, abandoned, and, So now we're in a position where you want your money back. Not only that, you want your two toes back, but you don't have a car to give him. How are you going to get your money back if you don't have a car to give him?
Yeah, well, I would certainly think that the car that is stored by the owners of the
It's
shopping
not stored
center.
by there. They got it towed. It's in some tow shop racking up charges.
Oh, yes, that's right, exactly. That's why
yeah.
I hired an attorney, because I consider it basically theft. And I would like to say the following. This is a Hungarian proverb. First you lie, then you steal, then you kill. And we are in the position now where this man has totally betrayed my trust.
You have a counterclaim against him, Mr. Day, for $400 that you say he owes you that you can't prove because you have no written agreement with him, and he says the agreement was just $200. Then he kind of said, well, and another $100 when he gave me the title. You are also suing him on top of that for $100 in labor and replacing the brake lines, which is a job that you sold to the present owner of the car. And you're trying to get that money from him so you don't just want the $600 you say the deal was for, you want an additional $100? How do you figure?
I am just looking at the purchase price. He has deposited $200.
Then why aren't you suing for $400?
Well, the $400 is left what I owe the owner, and I was not charging him labor in part of the purchase price. But
okay, my dear, your claim is for $500. $400 of it, I understand. What's the other $100?
A little compensation for the labor included in it. I've performed over 10 hours.
So we should convert you're arguing to me with one side of your mouth that the deal is for $400, but then you're arguing to me with the other side of your mouth that you should get $500.
Well, no, the $400 is due. I would think that.
Okay, no problem.
with
Can
the
you
work
prove
that
your
was-
case?
Yep.
Prove to me that 400's due.
I have the invoice from the original owner.
What do you mean the invoice
work
from the
performed.
original owner? Prove to me that this guy owes you $400. Show me how he owes you $400.
He wants $400 for the vehicle.
I don't care what the original owner wants. I'm telling you, prove to me what you sold it to this guy for. This guy, the plaintiff, prove it to me. Prove to me that it was a sale for $600.
Well, he has a friend that was actually present that admitted that the last time they were at my shop.
Do you want to call that friend to testify? Go ahead.
I don't know his friend's name, but he's a tall, dark-haired guy that always gives him a ride in a blue car.
Okay. What color's your car?
It's not blue.
No?
No,
All right.
it's not me.
I don't know what to tell you, my friend. You know, you have no evidence to buttress the way you say it's supposed to go, and you have no car to return to demand your money back. On your claim, Mr. Emery, against Mr. Day, my verdict is for Mr. Day. You have no car to return. You cannot demand your money back. And on your claim, Mr. Day, against Mr. Emery, to pay you not $400 but $500, because according to you that was the deal, just prove that was the deal. That's all you got to do, instead of coming here with your hands empty. So you also lose in your case against Mr. Emery. That's my judgment.
I deeply appreciate it, and may all of you walk in peace and grace.
Mr. Emery, let's begin with you. How do you feel about the case, the judge's decision in the case?
I think the judge was very fair, and I think the claims by the defendant is simply bovine scatology. That is BS. It's a lie. He has a lousy imagination.
I'm not surprised you feel that way. Okay, we know how you feel. Mr. Day, how do you feel about the outcome? You are a loser, too.
Well, I just lose out on my labor pretty much, and I donate a lot of my time to the neighborhood on labor anyway. It's really a simple matter. It could have been solved if he would just pay the money owed to the gentleman who was selling the car, and then he would be able to retrieve it from his tow lot. I still owe the gentleman the $400 in good faith that was selling the car. I'll take care of that out of my own pocket.
All right. I guess you'll have to do that. No question about it. All right, gentlemen. Thank you very much. I'm sorry you're both losers here. Harvey, what's your take on this case?
Doug, one of the ways of protecting yourself when you buy a used car, especially from a private party, is to demand a warranty. Now, a lot of times the car is sold as is, but you can always ask for a warranty, and it's up to you on exactly what you want. You could ask for a 30-day warranty on all parts and labor. You negotiated it with the seller, but I got to tell you, it is a good idea, even if you have to pay a little more, to get that assurance when you buy a used car.
Judges, does it bother you when people are using incorrect grammar?
It don't bother me when people use incorrect grammar. It really doesn't. But you do have to be precise about language. I had a professor in law school who was a federal judge up in Boston, may he rest in peace, John McNaught. And he told us this story once in a course that he was teaching, I think, on evidence. And this is in New England, so he had a New England accent, and he said he was in a trial where everybody had a strong New England accent. And it was a trial involving a shooting, and there was a tall man and a short man who got into an argument, and one of them was shot. And the prosecutor is asking a question of a witness who was there at the scene. And he says, "Now, sir," on cross-examination, "is that the man that was shot?" Just like that, right? And the witness says, "Yes, it was." Judge McNaught looks at him and goes, wait a minute. Did you mean the man that was shot by a firearm or shot in stature, right? And the witness said, "I meant the man that was shot by the firearm." And the prosecutor gets up and he goes, "No, Judge, I meant the one that was shot in stature. Can I ask a follow-up question?" He goes, "Yes, go ahead, and let's clarify." So some words sound alike, and sometimes they're words that really aren't alike, right?